not profit off the ignorant. Highlighted bold. It is a fact without further controversy. Blah, blah, blah. Continuing on with the narrative. Therefore, the time having elapsed to address / respond substantively by Attorney Michael R. Goldstein, whereas the offer for proof of claim otherwise has expired with no response, counter, or rejection, in parentheses, dishonor and default, based upon the various information / documentation contained within said demand dated February 19, 2024, and resent on February 29, 2024. Therefore, this notice of acquiescence acceptance provides an estoppel to the fact you snooze, you lose. Don't you like that? You snooze, you lose. In summing up, presumed persons can only be mere users of the name lawfully. Here, a right to have users of the name, comma, lawfully, have a right to have set off any and all claims against property of the state. Attorney Michael R. Goldstein and the firm Peyton Boland unconditionally warrants that any claim brought against any River Shores, River Terrace, River Bend resident, and in particular to the title of State of New York property, Anthony Rubio, asterisk, shall be administered under the rule of usufruct and or Federal Rule Civil Procedure 19. Take a look at that. What that is, Federal Rule Civil Procedure 19 requires all parties to be brought into the claim. So a state that issued the birth certificate would be required. Now that's at the federal level. At the state level, I think you could just bring it up and the judge will get it quickly. Comma, UCC 3-305, comma, UCC 3-202, to act in good faith to set off any claim against the name should there be any claim against said title to property, a registered organization by definition, and said firm shall do so without condition, compensation, or objection as an act of good faith in conjunction with said oath of office of said learned legal counsel from the firm Peyton Boland. To be noted specifically, the second demand dated February 29th is hereto incorporated into this notice without controversy. Again, highlighted in bold. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Next paragraph. Should attorney Michael R. Goldstein and or the firm Peyton Boland breach the terms of this agreement, the penalty, oh, this is lovely. You're going to love it. The penalty of said officers of the court shall be dictated under higher claim value law to include U.S. Treaty, U.S. Constitution, Federal Statute, Florida Constitution, and Florida Statute pertaining to human trafficking, peonage, conspiracy / deprivation of rights against rights, etc. As there seems to be an entire list of penalties for these depraved acts of conscience of involuntary enslavement. The victim or mere user of the property of the state shall be compensated according to the penalty guidelines for various schemes, conspiracy, and deprivation of rights. Bold and highlighted. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Next paragraph. And it is with great gratitude that contractually by and through the attorney's public oath of office / fiduciary duty to speak and or place into written word the truth, highlighted of course, the truth, the whole truth, and nothing but the truth in any and all matters in regard to superior contract performance requirement laws agreed upon and now to be acted upon by attorney Michael R. Goldstein and Peyton Boland to ensure no one's unalienable rights are violated, even if presumed voluntarily waived. So you understand why I presume, they get to presume you know, hi, I'm the person, right? No, we can't do that. Let me reread that. I'll read the paragraph again. And it is with great gratitude that contractually, by and through an attorney's public oath of office / fiduciary duty to speak and or place into the written word, the truth, the whole truth, and nothing but the truth in any and all matters in regard to superior contract performance requirement laws. See, they have to perform. They're the ones with the oath of office. You are not the one with the oath of office. Sure, you can volunteer. Sure, I'll be liable, no problem. But is that really what you want to be, liable for somebody else's debt? I don't think so. They've already taken your, or pledged your labor. Again, not the end of the world, but, you know, we have to play fair. Nobody wants to play fair, they just want to play to win. And that's where the problem lies. So, the truth, the whole truth, and nothing but the truth in any and all matters in regard to superior contract performance requirement laws agreed upon and now to be acted upon by Attorney Michael R. Goldstein and Peyton Boland, P.L., to ensure no one's unalienable rights are violated, even if presumed voluntarily waived. Comma, asking the ultimate question, who in his or her right mind would volunteer or consent knowingly and intentionally to be held liable for another's act, scheme, conspiracy, pledge, usurpation, collateralization for profiting off one's unalienable rights to one's own labor. I mean, again, who in their right mind would say, yeah, I'll be like, sure, no problem. Yeah, and they sit there and laugh. Nah, I don't think so. Continue on. Let us be grateful to our Creator for the truth, and the truth shall set us free. Bold and highlighted. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Next paragraph. To be noted, Jane Boland, partner of the firm, Peyton Boland, is a former city commissioner of the City of Oakland Park. Peyton Boland, P.L., remains as legal counsel for River Terrace and River Bend. During Ms. Boland's tenure on the commission, Ms. Boland was informed by email on or about March 27, 22 of a non-compliant city zoning issue in regard to said client's River Terrace. Today, this issue remains unresolved. It is my belief there could be a conflict of interest to be investigated. It is with implied trust that there will not be any unexpected BSO stop or unannounced visit. Next paragraph. Since Mr. John Joseph Caminiti, a resident River Terrace, who possesses a state of New York attorney registration number, likes to be active in the River Shores community. A resident. Attorney has the contractual opportunity to assist under Federal Rules Civil Procedure 19, providing first-hand testimony, being familiar with state of New York laws in regard to registered organizations, and if such, has legislative authority to be used as personal identification, etc., and which specific authorized trustee could set off any and all claims. Information has been provided to Grievance Committee for the 2nd, 11th, and 13th Judicial Districts, USP Priority Mail, on or about of July 20th, 2022, and Office of Court Administration on or about April 23rd, USP, the mail number, in regard to Attorney Caminiti. It appears Attorney Caminiti may too soon be summoned to testify in a legal proceeding that River Shores is a party to a claim. Highlighted in bold. Now let's work together toward post limine for the good of the nation and its people. So post limine means a restoration of prior rights. You can go look at that in the Lieber Code, look it up online. Then there's a scripture, Job 32:21 through 22. Let me not, I pray, accept any man's person, neither let me give flattering titles unto man. For I know not to give flattering titles. In doing so, my Maker would take me away. I put, may God bless you abundantly, your brother in Jesus. I signed it as authorized user for State of New York registered organization, Anthony Rubio, file number, property of State of New York. And then I had it notarized. State of Florida, blah, blah, blah. On this 20th day of March in the year of our Lord, the above was subscribed and acknowledged before me by the man as defined in Genesis 1:27, who reserves all his unalienable rights without recourse, and who, based upon the incontrovertible certified facts of evidence presented, absent proof of claim, otherwise, by and through those actors, persons with an oath of office and or trained in the practice of law, and parentheses, believes he is a spoliated and naked owner, an obligee by lawful definition, and a mere user with authorized and exclusive use of the name / person Anthony Rubio, State of New York, file number 013760 with the asterisk, because it all refers to that name, and to sign for said property for the benefit of the state as authorized, and as such in good faith affirms that he is a seeker of truth, justice, and honor in alignment with his faith to a higher power and its authority under universal laws, where all incarnated living souls are subject to those perfect, immutable, universal laws through divine justice. And of course there were witness signatures and everything. Anyway, that's the story. So a couple of notes to bring up. One, the attorney is never going to let this fly. So he's going to get even. It just, they have to. So it is highly likely, though I could not say 100% for sure, that based upon the partner being a former city commissioner, you know, it's a matter of simply picking up the phone and calling, you know, the cop and, you know, whatever. Is it possible? Yeah. I mean, it's just, that's how these things work. Will this be done? So now what I've done is I've provided a situation where, let's say, Attorney Goldstein leaves or goes away, and then I'm there and something happens. Well, remember the term plausible deniability. Well, he's away, he had nothing, whatever, blah, blah, blah. Am I being paranoid? Not really. It's just paying attention to what is. It's not about I like it, I'm afraid of it, you know. Remember, anytime you go to court, somebody makes a claim, it has to be proven. So I'm not looking to prove he's good, he's bad, whatever. All I'm looking for is just not to have any intercourse with him, so to speak, if you understand, any business. Couple of things. Attorneys cannot discuss this, I found out, and I really don't understand why. In a sense I don't. I should be clear. In a sense I do not understand why. For the simple reason, when it's brought up, they should smile and say, oops, game over, and just do what they're supposed to do, but they don't do that. There was a case, and I think I mentioned this previously. There was a case as the manager of the condo where somebody was suing the association, and went in the insurance, the liability carrier, and the liability carrier wanted me to testify, and he kept pushing. I mean, just kept pushing. And I said, you don't want me to lie, you're not pushing me to suborn perjury. And he said, no, you have to tell the truth. You can't commit perjury. And I says, well, you know, as we all know, you know, we've watched Perry Mason or any of those other shows, you know, when you testify, you know, you have to raise your right hand and swear to tell the whole truth, nothing but the truth, so help you God. Well, I cannot swear to tell the truth when I know something different. Now, anytime some court or lawyer wants to prove I own the name, fantastic. I'm certainly open to that possibility. What happened, not many years ago, I called the state of New York Vital Records and I said, well, the name is mine. Well, yeah. I said, well, can I get the original title or the original birth certificate? And Debbie, who didn't have a last name, answered the phone, and I said, well, I'd like the original, it's my name, right? And she says, no, it's not yours and you can't have it, and hung up the phone. I sent several letters to the Vital Records. Again, look, I'm not trying to be difficult with these people. You know, it just, you got to play fair. You can't play, you know, if you take something of somebody, fine, you owe them something. That's the law. It's not my law, it's their law. You know, folks, I'm not looking to embarrass them. This attorney, I think I mentioned it. One of the condo commandos threatened they were going to get Mr. Goldstein and threatened an 85-year-old woman with a certified letter. You know, I said, nah, we can't keep doing this. And this is not the first time the attorney sent the certified letter, and we just, you know, attorneys are human beings no different than you and me. We can't weaponize them to scare people, particularly when the law is there. It's not, I'm not looking to get even, I'm not looking to create controversy. We have to remember, I guess it's a national trade secret, even though it's all written there, which is another thing I'm confused about. The country operates under perpetual bankruptcy. There is no lawful money. There's only credit, Federal Reserve notes, or debt obligations under 12 U.S.C. 411 and 18 U.S.C. 8. They're not called debt, it's called obligations of the U.S. So, again, we should not, you know, why would you want the national debt going up? Because all we become are debt slaves. But, you know, you would want to set it off so, you know, it makes no sense. I'm not saying it well, but it just makes no sense. Why would you, I mean, you know, attorneys have children, government employees have children. They must like them on most days. Why would you want your children to suffer under a debt system that's created out of thin air? I mean, all it is paper. I just don't get it. But, and then people are always, you know, suing and looking to make quote-unquote money, and believe you me, if I could take it with me after I drop dead, you know, we'd be talking about a different story. But I think it's like a Monopoly game, you know. It all goes back in the box when you finish, so to speak. So I'm going to wrap up, but I have one more quick story to tell you. Locally, there was an attorney who had a shingle out, who did eminent domain. And I had taken the picture with the phone, and I kind of forgot about it. Maybe it was a couple of years ago, and I decided to write the lawyer. And wait a minute, I should get this up. It's worth listening to. It really is. I should have had this ready for you, but it's really fun what I wrote. So I write, this I did March 15th. Now remember, I just happened to do this. Good morning, Ms. Earl. By chance one day I was in Stewart and saw your sign out front and took a photo of it. I have a situation in regard to usurpation by the government that should be a no-brainer to enforce lawfully, but I'm not trained in law and procedure. There are many citations to reinforce performance, however, in parentheses, here is one from SCOTUS case to quote the U.S. v. Pee Wee Cole case 1951. And I quote the Pee Wee Cole case, whatever might have been Pee Wee's loss